Good morning, everybody, and thank you very much for joining us in what is the first of our 2024 social housing webinar series. This morning, we're going to be talking about delivering Section 75 affordable housing contributions and really what happens if the developer becomes insolvent. As I say, welcome to our first in the social housing webinar series. My name is Fiona McLeod. I'm a legal director and solicitor advocate, and I sit within our disputes team. I've got a particular interest in the living sector and in public sector housing. I'm joined today by my colleagues Jenna Monteith and Elaine Peterson. Jenna is a legal director in our real estates team. Jenna works within our living sector practice as well and has a particular focus on real estate transactions for the public sector, including affordable housing providers, local authorities and non-departmental bodies. Elaine is a partner within our real estate team as well, and Elaine leads the real estate restructuring team. She has extensive experience acting for insolvency practitioners and lenders in distressed asset sales and providing advice on real estate issues arising as a result of insolvency. So I'm going to pass over to Jenna in the first instance, and I'll be back at the end when we're looking at questions. Jenna.
Thanks very much, Fiona. When Elaine and I were planning how we were going to run this session this morning, we thought we would treat it more almost like a discussion between us, as would be the case if one of our RSL clients was to phone me in the office and explain that on one of their development sites, they had heard that their house builder partner had become insolvent or had gone into administration, or something had happened, and the RSL was really looking for some advice around that scenario. So we're not, just to kind of set the scene a little bit, we're not going to speak closely to slides. It's going to be more of a kind of chat between Elaine and I, and it will really kind of indicate the kind of chat that Elaine and I would have behind the scenes, if you like, when deciding how to initially advise any RSL that contacted us in this situation. So what I will do first of all is kind of set the scene in the way that I would set the scene for Elaine, and I'm just going to assume some facts and circumstances here, kind of broadly representing a kind of typical affordable housing site delivery arrangement as between an RSL and a house builder. And so what I have in mind here is a scenario where an RSL has contracted with a house builder on golden brick terms for the delivery of the affordable housing contribution on a house builder's larger site. Thinking around maybe 5 phases of 10 units each, with the transfer to operate, like I say, on a normal golden brick basis, where the house builder will complete the initial works to that golden brick point. Once golden brick's been achieved, the ownership of those plots where golden brick has been achieved will be transferred to the house builder at that point, and from that point onwards, the house builder will complete the construction of those homes to the point of handover in terms of the build contract. We'll probably imagine that the missives will be certainly initially suspensive on detailed planning permission being achieved or obtained by the house builder, and that the house builder site's probably quite large. I mean, as everyone on the call will know, probably, or the likelihood is that there will be a 25% affordable housing contribution on the developer's larger site. So to accommodate 50 units, that would be quite a large site in the first place, and that site will require various supporting infrastructure, likely to include an access road, a suds pond, maybe some active travel routes across the site, and all of that kind of thing. And in the normal way, the house builder's obligation in terms of the construction contract to the RSL will include completion of the necessary infrastructure so that the completed units at the point of handover in terms of the build contract can be occupied and used by the RSL for affordable housing. And generally thinking along the lines of the fact that contract will be quite long term. Probably it'll take 12 months for those supposed 5 phases all to reach first of all the golden brick point, and then after that actual practical completion and handover. And the reason I've chosen this kind of scenario for Elaine is just to demonstrate how relatively complex the golden brick handover arrangements are, but also because there are just a number of scenarios or a number of kind of realities, I guess, that will exist during the life of that contract. We'll have different, facts across the piece. Initially, the house builder will own all of the land, and the RSL won't own anything on the site because there's been no golden brick achieved. But then later on down the line, we'll have a situation where the house builder will still own some of the plots and the RSL will own some of the plots, but none of the plots will actually be complete and have been handed over at practical completion. And then again, a bit later still, we'll have some plots where handover in terms of the build contract will have been achieved, practical completion will have been achieved prior to that. But there might still be some plots that are still within the house builder's ownership because those last plots to be delivered haven't reached golden brick yet. And then, towards the end, it's likely to be the case that all of the plots will have been transferred and will be within the ownership of the RSL. And some of those plots then will have been completed and handed over and then will be in the defects liability period post-completion, and some of the plots will be just about to be completed in terms of the build contract. So there's all of that is just to say that over the life of the contract, and by that I mean both the sale contract, the missive, and this associated build contract, there's just a number of different factual scenarios that will exist. And I think what we wanted to think about was just at any one of those stages, if it was to transpire that the house builder had suffered an insolvency event or had gone into administration or liquidation, then where would that leave RSL at any given point across the piece there? So I think the first thing Elaine and I were going to do was really just to speak around some of the kind of basic aspects of insolvency and the kind of first questions that we would look to establish as between us.
Thanks, Jenna, and I think that's totally the right place to start. When we have colleagues and clients speaking to us about an insolvency scenario, quite often they've been kind of thrown into a situation they weren't expecting to be in, and really in establishing what's going on in any of that scenario, the best thing is to kind of almost go back to basics first of all, because as Jenna talked through the scenario, there's various different things that are going on. So really the starting point is what is actually happening with the house builder in question. And the term insolvency gets used quite interchangeably. You'll have seen in the press, there's often reports that go out to say, a particular entity is struggling financially or it's about to go bust. But what does insolvency actually mean? Well, a company is insolvent if either they don't have enough assets to cover its debts, or, which is probably going to be quite likely in this scenario, if it's unable to pay its debts as they fall due. So there's some kind of liquidity issue. Now, the first thing that we would normally always try and establish is where are they in that process and which insolvency regime is actually applying, because that is going to dictate how the circumstances are going to play out most likely. So there are various insolvency scenarios that can occur, but probably the one that's going to be most familiar and probably most relevant here is administration. And administration is the process where the company is still in existence, but it is placed under the control of a registered insolvency practitioner who is an administrator. And normally the objective of administration is rescuing the company as a going concern, if that's possible. Now, whilst a company is in administration, it's placed under a protective bubble effectively, which is known as the moratorium. And what the moratorium does is it prevents any action being taken against the company whilst it's in administration. So that's why administration is such a powerful rescue tool, because it allows the company some breathing space to get its affairs in orders whilst it's in the restructuring process. at the end of the administration, the company might be returned to the control of the directors. It could go into liquidation, or the company might be dissolved. So just a bit of a kind of side note to that, and we'll probably come on to talk about this a bit more, but establishing where the company is in the process is essential, and that also just bearing in mind that that might change further down the line. The other scenario that's probably going to be most relevant here is liquidation. So sometimes, unfortunately, it's just not viable to sell the business, and the company might be placed into liquidation, and the company's assets will be sold off, and the proceeds of sale are effectively distributed amongst the creditors. And unfortunately, liquidation is normally the end of the road for the company, and eventually it's going to be removed from the company's register. So it's useful in the first instance to establish, has the administrator or liquidator actually been appointed, or do they look like they're about to go into the appointment process, and is it administration or liquidation that we're dealing with, because that will really dictate who the relevant parties are that you should be speaking to. Now, the kind of second thing that would then take us on to is, well, what happens to any contractual arrangements that have been entered into? And just because one party to a contract becomes insolvent, it doesn't, in the absence of a specific term in the contract dealing with insolvency, actually have any legal effect on the contract itself. So your contract is still in existence, but what it's really likely to have is a significant practical effect. Now, in England, a liquidator has the right to disclaim onerous contracts, but that is not actually a statutory power which exists in Scotland. However, an administrator or a liquidator in Scotland do have the power to they don't have the power just to simply terminate the contract, but what they can do is decline to perform the contract, and that places the company into breach of contract. So that obviously has a significant effect on whoever is the contracting party, because then they would need to either apply to the court to order that the contract is performed, and that will normally happen in exceptional circumstances. And normally the remedy for the other party would be a claim for damages against the insolvent estate. Now, a claim for damages might not be worth very much, because it will be what's known as an unsecured claim in the insolvency, and these types of claims are only paid out after all other prior ranking claims have been paid in full. So whether as an unsecured creditor you're going to receive any funds for a breach of contract claim will really depend on the specific circumstances of the insolvency, and really how much money is left in the pot once other parties have been paid out. However, it's not all doom and gloom. You might find that an insolvency practitioner may still want to go ahead with performance of the contract, especially if that contract is an asset for the company and a way of generating income for creditors. But we might find that they might want to amend contract provisions or make it more something that they're able to deliver. So kind of takeaway from this kind of overview is really, if you're in a situation where you've entered into a contract with a company that then becomes insolvent, it's always worth opening up those discussions with the insolvency practitioner in the first instance, and really as soon as possible, to try and find out their intentions and ascertain if you can agree a way forward, as the commercial reality might be that there is some kind of middle ground which can be reached. So really that would kind of be our starting point, Jenna, in terms of whatever the set of circumstances to follow from that.
That's really interesting, because I imagine if one of our RSL clients was to hear kind of in the press or otherwise get wind that a house builder had gone into administration, but if they were to go down onto the site, it might be the case, I think, that there would still be quite a lot of activity ongoing. So I think I guess what I'm thinking is what kind of practical steps would we be advising our RSL clients to take to establish definitively what has actually happened?
Yeah, and that's quite a common occurrence, is that you see one thing being publicised and another thing happening on the ground. So it's really trying to get to the bottom of what is actually happening. Because administration or liquidation is a court process, the information tends to be readily available and quite quickly, and also details get published at Companies House as well. So it's something we can ascertain for clients really quickly in terms of just doing quite a straightforward search. The market in Scotland is also quite small, that we probably know most of the insolvency practitioners as well. So it can be helpful in terms of just establishing exactly who is dealing with a particular appointment. And a lot of this is getting to speak to the right person and making those connections for clients as well, so that they can open up discussions.
And I guess at the same time as establishing what exactly is going on the house builder side, from our RSL perspective, what we would want to be doing would be establishing our own current position, and by that I mean establishing where we are in terms of the delivery of the contract and what obligations have been performed and what obligations are still to be performed. So really we'll be thinking about, I guess in the first place, if we have entered into a missive which is conditional on detailed planning or some other, SIs being obtained, or any of the other kind of common suspensive conditions, whether or not those have been purified, and therefore whether or not we're kind of in contract and house builder has been working towards the completion of the initial works, the golden brick works towards that first title transfer. So just so I'm clear, and I think I know the answer here, but is it the case that even if we do have a suspensive contract, so I guess in many ways nothing has really happened from RSL's point of view, because we've been waiting on detailed planning coming through. It's not the case that RSLs can withdraw from the contract at that point. There is basically no rights for RSL to terminate purely because house builder has gone into administration or liquidation. Is that right?
So your starting point is what is your contractual agreement, and you would be checking that to see what the terms say. In the event that there's no specific right to terminate, but just because one party's become insolvent, then your contract is still in existence. And I think on the point about the missives being conditional, I think what we'd really be thinking about is what are they conditional on? Is it something that the administrator or liquidator is going to be able to deliver on? So you mentioned there about it being, your planning consent might be in, and we're just waiting to see the outcome of that. It's quite possible the administrator or liquidator might think, well, actually, that's going to increase the value of the site if the planning consent is granted. We don't actually need to do anything which puts our personal liability, because what I should have mentioned at the start as well is when the administrator or liquidator are appointed as officers of the court, so they have certain duties, and what they are what they will have a nervousness about is their own effectively ability to be able to take appointments and to not incur personal liability. But where it's something which is the company had already set in motion and it's not detrimental to creditors, they may well be happy just to let that play out. So for example, if it's conditional on planning, it's hard to see why you wouldn't wait to see what the outcome of that planning consent is. But again, that's why having those initial discussions with the administrator or liquidator is probably quite helpful, but also potentially informing them as to where you are with that contract, because when they are appointed, they will try and gather as much information as they can at the outset to basically build up a picture of the company and its affairs. Now, I think it's fair to say when a company is at a point of distress, there's lots of competing priorities, and with the best will in the world, it's quite possible that all information might not have been passed over, or the directors might not have been in a position to give all that information to the insolvency practitioner. So where you have a site where you've got a particular interest in it, that is the benefit of being able to speak to the insolvency practitioner to say, look, we are at this point here. This is how we think you might be able to deliver it, or this is kind of the best case scenario. And it might be a case of working back from the ideal situation. But having that discussion is actually quite a useful way to kind of, first of all, get your site maybe to the priority, because it maybe makes it a bit of an easier one to deal with because you've got somebody who's providing information on it. And second of all, to actually ascertain what the position is sooner rather than later.
Yeah, and I think that's where our RSLs will generally be in quite a strong position here, because typically RSL might have like a clerk of works who's actually on site, who, when we're talking about this kind of scenario where there will be different phases that are all at different stages, both in terms of where they are along the progress towards practical completion, as well as some different parts of the site that are likely to be in different ownerships as between the RSL and the house builder, just depending on kind of where the music stops, if you like. RSL is going to have that really strong kind of knowledge about the site, about construction progress on the site, as well as the kind of factual legal position as to where we are around achievement of golden brick status and ownership handover. So it sounds like RSL can gather as much information as they can about where the site is at, what progress has been to date, and what the arrangements are going forward, and then use that in its to liaise kind of effectively with the administrator quite early in the process, and that would be a good way to proceed. Would that be fair to say?
I think that's definitely the way to approach it. And we do find that the insolvency practitioners are normally pretty receptive to speaking with stakeholders, because it's really in their interest to be doing that, because where they're trying to get to is a point where they can go through the administration or liquidation process and bring everything to a neat end. And having kind of loose ends or sites where they fall into the too hard pile is not really where they want to be. So the RSLs in these situations are probably part of the solution to a certain extent for the insolvency practitioners, at least being able to establish what they want to try and do with these sites. And a lot of this is going to come down to, what stage is the site at. Some, presumably, Jenna, you're obviously kind of here with your RSL hat on. Some are probably going to be more straightforward than others for the administrators to take on and be able to complete.
Yeah, I mean, that's absolutely the case. And I think we can think about, some sites, some house builder development sites will be quite straightforward in the sense of there being, fewer infrastructure requirements, and maybe there's the site's more straightforward in terms of requiring less by way of remediation works, versus more complicated kind of larger sites that might have really heavy infrastructure requirements, and Section 75 obligations to deliver kind of public infrastructure. And of different kinds, that could be really quite onerous, such as contributing to the development of a high school or a train station, or myriad things. So yeah, absolutely, some sites will be more complex than others, and I think that is a good point and a good kind of place to go with this, actually, because I think one of the considerations for RSLs when entering into agreements with house builders in the first place is obviously going to consider the wider infrastructure of the site, and how the site will sit within a wider community, and to what extent local amenities are accessible, and all that kind of thing. So in scenarios where there is quite significant infrastructure that's to be completed, and even thinking about the situation where house builder site might be quite large, and the RSL's portion of the site, the affordable housing land forming part of that site, might be quite some distance from the nearest public road. So access to our affordable housing site will be dependent on the construction of an access road. That would be quite a common condition. And I think what you are saying is, as much as we've established that RSL can't terminate the contract with a house builder because the house builder's gone into administration or liquidation, equally, I don't think RSL would be able to procure necessarily performance of the house builder's obligations in terms of contracts. Would that be fair to say?
So there's a couple of things coming out of that. On the termination point, just to reiterate, what you'd want to be doing is checking what the contract says to see whether there's any grounds. And if there is non-performance, like there is with any contract, then you might have an ability to terminate the contract because the party you've contracted with is just simply not performing. And on that, what I would say is the administrators and liquidator or liquidator are unlikely to, their appetite for this is not to sit and be just difficult or to obstruct the development completing. So they might say, listen, this is not in the best interest of the administration for us to perform under this contract, but they're unlikely to block development. So if it might take them a bit of time to get to that point to work out exactly what they're going to do with the site. But if, as an alternative, the RSL was going to look to, take that bit of the site and arrange alternatives for building it out, the administrator is probably going to be cooperative in terms of releasing them from that contract, because that gives certainty. And it's not in the benefit of the insolvency practitioner to have a contract sitting there where there's not really any certainty as to whether an unsecured claim might come out of the woodwork at a later date. So in terms of just getting the company's affairs in order, they are probably going to be helpful, even in terms of, even if the outcome is not giving you the one you want, which is to build it out. The second question on procuring performance. So this kind of goes back to the insolvency basics at the start. So they can, you can't compel them to perform the obligations under the contract if they've determined that is not going to be in the best interests of the administration. But it's not all negative, because just because they aren't obliged to perform doesn't mean that they won't. And we have acted for insolvency practitioners where they have been appointed in a house builder scenario that has become insolvent, and they have completed parts of the site or have finished off the development. It all comes down to what the development is and how feasible it's going to be for them to be able to do that. So although the straight answer to your question is no, you can't compel them to do it, but that doesn't mean that they won't do it. So it might be more of a positive situation than you think you're going to be in.
Yeah, and I think it's in addition, even if it was to be the case that the administrator or the liquidator wasn't going to carry out those works, from RSL's perspective, you're most likely to be in the situation where, even if the house builder isn't going to complete that access road to carry on with that example, there should be the necessary rights attaching to the parts of the site that have transferred into your ownership for you to undertake those works yourself. I mean, that might not be the ideal situation, but it would mean at the end of the day that your portion of the site, you will be able to access it and use it for the intended purpose. Most likely is going to be the case that there would be a deed of conditions which had already been registered over the site and which would provide the necessary rights of access for all the different portions of the house builder's larger site, including RSL's affordable portion. And there may or may not be rights within that for the construction of the access roads. But if there aren't, we would usually expect that any disposition or conveyance of part of the site to the RSL would include the necessary rights required, just to make sure that RSL, if this situation was ever to arise, would be able to construct that access road so that the site could be used for the intended purpose of providing affordable housing. So I guess that's just an example of how, there is probably going to be a way through. It's not necessarily always going to be a kind of doomsday scenario.
And I think where we always start with these situations, Jenna, is we would speak to the client to see, look, what do you want to achieve from this? And probably in most situations, it's performance of the contract on the original terms. And that, just the way the insolvency regimes work, that might not be where you end up, but we would work back from there in terms of, well, let's try and get you as close as possible as we can to that. And if that's not on the table, what can be negotiated? And when you're mentioning there about access roads, etc., if the administrator is going to be building out parts of the other site or the rest of the site that are maybe easier for them to do, or taking it to a certain level, then it might be that if we can make them aware that, look, actually, if we could even get this access road extended down here, that would make life easier for whoever's picking it up, in terms of us taking it forward, then that might be something that we can negotiate. A lot of this is a commercial negotiation, albeit within the kind of confines of what the insolvency practitioner is actually really in a position to be able to give. So it's kind of being aware of that kind of commercial driver on it that can be quite helpful. Just on your rights point, and I think if we could maybe just pop back a slide, because I think we're still working our way through these ones. On the wider infrastructure point, I think it's a good point, and I suppose the best way to deal with insolvency is kind of almost at the start, when you're hopefully thinking it's never going to come to fruition, is that kind of forward-looking piece. So when you are looking at your site infrastructure, it's thinking about, well, what would happen if, knowing all of this and how the insolvency regimes work, what would happen if the developer went into administration. And also just going back to that other point that I mentioned at the start, that quite often if the company's been under financial strain, perhaps documentation's maybe not been quite so orderly or granted at the time when it was maybe supposed to be. So what we would always recommend is, as well as assessing the insolvency situation, is do a bit of an audit of, are your contracts all in place that you thought were in place? What do they actually say? What rights have been granted? Where are those rights sitting at that particular point? Because when a company becomes insolvent, there's almost kind of a line in the sand that's drawn, and there's quite a significance between things that have been granted or entered into pre-insolvency to those which are not entered into prior to that date. So just understanding that as well is probably quite a useful exercise to do at the outset.
So being quite strict, I guess, in terms of where we've contracted on the basis that house builder will deliver documentation to us at certain points in the process, making sure really that we do get all of that documentation that we're entitled to when it falls due, just to make sure that we do, as you say, have everything, that RSL has everything that it thinks that it has, and that there's not documentation that maybe we've agreed can follow at a later date, or, you know, as sometimes happens in any normal commercial scenario, you know, decisions are made in the moment to do things and behave in a certain way. So I guess just being mindful of that.
I think that's right, and a lot of this is you know, it's the kind of ideal scenario. So that's not always going to be the case, and there'll be decisions made in different cases. I think from what I've gathered from you, what's probably quite significant with these types of transactions is they can go on for a long period of time. So what might happen is the covenant of a particular entity that you're dealing with at the very outset might not necessarily be the same covenant, just given I mean, we've been in quite an interesting period financially, haven't we, and economically, which has particularly been relevant for this house building sector. So it's bearing that in mind. And also, if we are in a scenario where an insolvency event occurs and maybe the documentation is not quite where we would have hoped it to be, it's basically trying to see what we can do to improve the position as much as possible. And some of that might be, again, liaising with the insolvency practitioners to try and make them comfortable as to why a particular document, which was supposed to be granted, it, you know, it's really not increasing their liability. It's for their benefit and the company's benefit, just for that, even that element to be completed.
I think what you mentioned there about thinking about if RSLs think about insolvency as an event before it actually occurs, and kind of keeps that in mind during the initial due diligence process is an interesting and good point, because I was thinking when we were talking about this before about Section 75 obligations more generally, and typically it will be the case that the house builder will enter into a Section 75 agreement as part of the planning consent process, and that Section 75 agreement will affect the whole site and will be registered against the title to the site, and therefore will affect all parts of the site. And it's not unheard of for affordable housing land to be excluded from some Section 75 obligations, but it's also common for the whole site, including the Section 75 land, to be burdened with the terms of the Section 75. So there might be an obligation to make an education contribution, for instance. That's quite a common one. But what we would often see is that the contract between the missive between the RSL and the house builder will provide that the house builder will meet all of the obligations that apply to the RSL land, and it might even go a stage further and look to indemnify the RSL essentially from any costs or losses arising. I suppose that's going to be quite an important clause to consider in this scenario where the house builder has become or has gone into administration, because it's likely, I guess, in that scenario that the administrator may not perform that obligation, and in which case RSL would be then kind of on the hook to the planning authority for the performance of obligations in terms of the Section 75, which wouldn't have envisaged necessarily being the case. So I guess that is, Section 75s are a good example of an area where RSL should just be alive and aware of the obligations that would apply, that potentially could apply if this scenario where the house builder was to go into administration was ever to come to pass. So it's just about just a thorough due diligence exercise at the outset to understand the possible extent of liabilities that could arise there. The other point, and I'm not going to get into this in too much detail, but just thinking specifically about the construction aspect, the scenario that we're discussing here envisages that there will be a missive as between the RSL and the house builder, which deals with any suspensive conditions, as we've discussed, and then completion of the initial works up to the point where golden brick's achieved, and then transfer of title after that. And then typically there would be an associated build contract, and the house builder would complete the units to practical completion and handover stage in terms of that build contract. So I just wanted to briefly touch on the fact that typically in that scenario there will be RSL will benefit from collateral warranties which will have been granted by the main subcontractors and consultants, and typically those collateral warranties will include step-in rights for the benefit of the RSL. So the RSL could effectively kind of step in to the house builder's shoes and look to the subcontractor to perform the duties that would otherwise have been performed for the benefit of the house builder. I think the construction package in and of itself would be something that would be looked at, that would need to be looked at in some detail, just to understand to what extent there are mitigations in place. It is true that typically a kind of standard SBCC build contract would include as a termination insolvency as a termination right or a grounds for termination, and there may also be a bond in place for the benefit of the RSL as the employer under that build contract. But as everyone knows, I think the construction package will be complex, and as part of that kind of information gathering exercise that RSL would go through if it did transpire that the house builder contractor had gone into administration or liquidation, would certainly be something that RSL would do kind of quite early on, just to establish what the rights are and what benefits and mitigations are available in terms of that construction package. And that kind of leads me on quite nicely to the fact that all of this the exercise of reviewing all the documentation and kind of thinking about next steps and how to proceed, and having the facts to discuss with the administrator or the liquidator is all going to incur cost, I imagine. And I don't know if this is probably just wishful thinking on my part on behalf of our RSL clients, but Elaine, would there be any space for RSL to recover their costs from the administration arising from the fact that the administration has taken place?
I'm going to try and be as positive as possible about this. I suppose you might have a breach of contract claim under your, it depends on your underlying contract, doesn't it? But the thing about that is you're going to be an unsecured creditor. So it's a bit we were mentioning at the start, whereas you're basically at the back of the queue. There's quite a strict order of how claims are paid out, and unsecured creditors are towards the back. So just on a kind of basic level, you're only going to get really what is left in the administration at the end, and it'll depend on what other creditors are in that pool as well. But I think what all of this really shows is you're trying to kind of piece together these different bits of the jigsaw, aren't you? You're trying to work out exactly what's happening with the company, what are the intentions, what documentation have you got, what's your commercial position. And what we try and do with clients is really kind of come up with a bit of a strategy as to kind of the best way to take things forward and kind of steady the ship as much as possible. Because quite often there are different levers that you can pull to try and improve your position. And obviously that's important for RSLs as well, because they've got duties in terms of presumably internal reporting and trying to kind of deliver sites in, as efficiently as they can as well, so for meeting their own internal objectives. So it's all about kind of piecing this together and working out what is going to be the right course of action in terms of trying to get yourself into as good a position as possible. So you might not be able to recover everything, but it's also just in terms of trying to get some kind of delivery on, or allow the sites to be delivered, which I assume in most of these scenarios will be the kind of main objective.
Yeah. Okay, well, I think that was kind of everything we were going to discuss between us. And I think what we wanted to finish off with was just some kind of practical tools and points for RSLs to be aware of and to think about. And the first one is really, as we've kind of discussed, about just the pre-insolvency position and thinking ahead that RSL should just, insofar as possible, think ahead to the scenario where, much as it's maybe unlikely to arise, but to think ahead to what the position would be if the house builder party did become insolvent or went into administration or liquidation, and just to tackle all kind of due diligence and to consider the commercials up front just in that context. One of the things that we're seeing more commonly at the moment, and certainly this is becoming really common in England, is financial distress provisions in contracts, which basically look to house builders to provide kind of ongoing information about their financial performance, essentially, so that RSL is kind of up to date with what the current position is. Elaine mentioned it earlier on. These contracts can be pretty long term in terms of how long the period of time between signing and ultimate completion. So the position and financial covenants can change. So it can be useful for RSLs just to have a bit of a window during the life of that contract as to what's going on. Just so for awareness and for forward planning purposes. Aside from that, in the event that a house builder partner did become insolvent, as we've discussed, it's the most important thing really is to ascertain the up-to-date position, both in terms of what the situation is in terms of the insolvency. Is it administration or liquidation? Who is the administrator? And just to gather as much information about the insolvency as possible. And also at the same time to review contracts and understand where matters sit in terms of performance, with a view to engaging with the insolvency practitioner where that's possible, with a view to working towards the kind of final outcome. And as part of that, identifying what information is available, about the site, about where we are in terms of completion, what's still to be done, and just all of the relevant information that will really assist with arriving at that kind of final landing place, and most generally of all, just being aware of the commercial drivers. Elaine's discussed that the insolvency practitioners are officers of the courts and have got to behave in a certain way in accordance with their duties. So it's important to be aware of that and to consider that in discussions with the insolvency practitioners. Have you anything to add to that, Elaine, or do you think that sums it up?
I think that's a good sum up, Jenna. And I think really the kind of key message here is we appreciate that things can be quite fast moving as well, because you can move quite quickly from kind of hearing that things are happening to then, being told, well, actually such and such is happening on site, or you get bombarded with kind of press releases, etc. So it's definitely just unpicking all of that, taking a bit of a breath at the start, but also the sooner you kind of get on the front foot with these things, it tends to be that you've got more options available to you. So that would kind of probably be the way I would sum it up as well.
Okay, great. I think we've got time. We don't have much time. We've talked on all about this, Elaine, all through our time pretty much. I think we've maybe got some time for one question, if we've got some questions.
Yeah,
Fiona?
I think so. Thank you very much, Jen and Elaine. Very interesting topic on what is no doubt at the forefront of a number of people's minds that work in the sector at the moment. One quick question, we've got a few questions, so we'll need to follow up with people post-webinar, but one quick question that I have is, if the administrator offers to continue to deliver the contract, but on amended commercial terms, so for example, at a higher price, would the RSL need to accept that, or can they cancel that contract?
Do you want me to say that one, Jenna?
Yeah, I think so. Please.
So it's possible that, I think I actually did kind of touch upon the fact that the insolvency practitioner might be willing to perform the contract, but on amended terms. So when we're issuing any contractual documentation on behalf of insolvency practitioners, there's certain kind of boilerplate wording that they always want in, which basically makes it clear that they, as individuals, because it's the individual taking the appointment rather than the actual firm of the insolvency practitioners, so to exclude their personal liability. So any documentation which you're entering into, they're probably going to want to amend that to make it very clear that they've got no personal liability. I suppose what they might also say is, look, we can deliver part of this, but not this part. That's just a commercial negotiation. You're not obliged to enter into a revised contract, but I suppose the thought process is what you're being offered, putting you in a better position than them just not performing at all. So it's a commercial negotiation, but you're absolutely not bound to buy it, but they might not enter into any alternative.
Okay, thank you very much. Well, thank you both, Jenna and Elaine, for this morning's session. We'll wrap that up there. And all that remains for me to say is thank you very much for joining us this morning, and we look forward to speaking to you all again soon.